Glad to have you here. I'm Debbie Hudley. I'm CEO of the Pre-Accelerator Program with Stubbs Alderton Markiles. So, thank you, Steve. The Pre-Accelerator where you're sitting today is this entire office is an accelerator for early stage startups. And it was founded by Stubbs Alderton as a way to give back to the community, but also a way to decrease risk for investors and help build a startup ecosystem for these really early stage founders that don't have access to capital, that need additional resources, that need to refine their market, their business model, learn how to pitch, and create relationships utilizing our network as a law firm. And also to get great legal expertise from our attorneys. And so they get 24/7 access to the office. Close to now $500,000 worth of perks that will cover overhead expenses. When attorneys are here on site, they can walk up to an attorney and ask them legal advice, non-billable legal advice, and have a fixed fee legal package that we set them up with for other items. And we have 82 mentors now, Steve being one of them. I think there's a couple other mentors in the audience that come in and do 2 hours once a month for advice for the company, really providing a value-first approach to them. So Stubbs Alderton Markiles is a full-service business law firm. So we do everything from incorporations to intellectual property, both transactional and litigation, for trademark and copyright. Mergers and acquisitions, middle markets, public securities, business litigation. So everything under one umbrella that a startup or a business would need for their legal representation under one umbrella in-house. So Kevin DeBré is the head of our intellectual property and technology transactions practice. So he really provides a lot of expertise on if you have intellectual property and you have a defensible product, what do you need to spend your money on from a business perspective, what strategy long-term for your business and for the intellectual property. So we'll talk a little bit more about that. He's a registered patent attorney that does not practice patent law anymore, but he does advise companies on patent strategy. So we'll talk a little bit about that tonight as well. So without further ado, I will turn it over to Kevin DeBré and let's take it from here.
Heidi's been after me to do this for several months, and my reluctance was, I don't want to tell everybody my trade secrets, and they won't need me. But here I am. Take notes if you care to. Actually, we're going to make this available, right, on our blog?
On the blog, I'll also email it to everybody who's attending.
All 6 hours, so you're free to watch it. And I joked earlier about this not being interactive, and I was kind of serious, actually, because I like to have it be interactive, but the honest truth is the real cool, interesting stuff is kind of towards the end, and I do have to get through the beginning to get to the end. And so maybe if we can kind of do that, and I can get some momentum going, and we'll see how it goes. And if there are puzzled looks, I'll pause and ask if there are questions. But preferably, we can kind of get through the kind of interesting stuff and then have Q&A at the end. Sound good? All right, so yeah, this is us. We do corporate securities, mergers and acquisitions. That's what's going on there probably. We actually have a business litigation practice. We have a very vibrant digital media and entertainment practice as well. You may not know that. We recently did an M&A deal with Alauzi Software, representing the company that was recently sold, and then that's where I live in our intellectual property practice. And here's a little bit about me. I was an engineer before going to law school. I was involved in alternative energy technology before it was called clean tech, and I am a registered patent lawyer, but don't hold that against me. What that means is I took an exam and am licensed to practice law before the U.S. Patent and Trademark Office. That means I can file and prosecute patent applications. We're going to talk about that in a little bit. But like Heidi said, I don't do that anymore. That's for people who do that day in and day out and are really good and specialized at it. And I work with a lot of patent lawyers here in town and elsewhere in the country because they provide a more cost-effective service in filing patent applications than if I were to do it by just kind of dipping in and out of it. I also am a contributing author to a probably the premier treatise in California for trade secrets and for lawyers. and I do mentor startup companies here and entrepreneurs. I do office hours at the USC Business School Incubator. And so here's kind of a list of clients and companies that I work with, and this is all very interesting. There's a bunch of logos that I found on the internet.
I didn't catch that.
This little company, when it was actually a little company in the mid-90s. So I had Silicon Valley on this previous slide for the reason that I was with a major Silicon Valley law firm in the mid-90s, and it was a real heady time. I mean, companies were getting funded by VCs like on business plans, and we saw how that worked out. They were also going public, and one of those was Cisco Systems, and at that time they had 2 in-house lawyers that were completely overwhelmed, and I was sort of the guy that was getting all of their development and licensing deals and tech transaction deals, and that's what really kind of made me aware that this really is kind of an area of law practice that wasn't really recognized or taught in law school, where there might be a career in. But this is the reason why I do what I do. These are the clients that I work with, the faces behind the logos, scientists at universities. I do a lot of work with faculty and principal investigators at universities who are developing tech in the labs, licensing it out of the universities, and then spinning out startup companies. So most entrepreneurs know that intellectual property is important, right? It's a barrier to competitors. It's an asset that can be borrowed against or financed. It is a source of comfort to investors. Investors feel good when they know that there is defensible intellectual property behind what the company is doing, the company's products or services. And by having like the patent pending sign on it, on a product, not only is there a legal reason, but there's a marketing reason for that. Companies believe that they are sort of validated in the marketplace. They are shown to be pioneers or leaders in their industry by having patents. So entrepreneurs know these things, but what they don't know is how to effectively use and monetize and protect their intellectual property. And most importantly, and that's this poor guy here who is the patent lawyer, entrepreneurs don't know how to ask or what questions to ask their patent lawyers. They often don't have the terminology right. They aren't sort of focused in what information they need in order to make informed decisions. So in 45 minutes or less, that's my job here, is to give you a little bit of education, but I'm not going to tell you what to do because that is very specific to each entrepreneur's business and how they approach the market. So quick sort of intro on U.S. IP protection, intellectual property protection. 4 types of IP generally: patents, copyrights, trademarks, and trade secrets. So patents protect inventions, and inventions can be products or what are called articles of manufacture. They can be chemical compounds, or what are called compositions of matter, processes or methods. Trade secrets protect confidential information, secret information. That supposedly is the Coca-Cola formula. Don't take notes. But it can also be things like bill of materials or specifications or customer requirements. Not just a customer list, but a list of customers and what their specific requirements are in terms of how they want the product configured, or quantities that they historically have ordered, or maybe pricing that they are accustomed to receiving. So trade secrets. Copyrights. Copyrights protect not ideas, but the expression of ideas. Okay? So, and this could cover a lot of ground. Of course, we know about movies and audio recordings and scripts and musical scores. That's Good Morning to All, the happy birthday song that recently was determined to be in the public domain, no longer copyright protected. So copyrights do have a finite duration. But interestingly, this is user interface from League of Legends. User interfaces in computer games can be protected by copyright. And even more nuanced than that is look and feel. The look and feel of how a game or a software program operates. So the actual functionality, the actual mechanics of a software program are not protectable by copyright. The code is, as the code expresses, what the look and feel of the the software program does. Make sense? Okay, good. Okay.
Just to clarify, so you could separately, you could copyright the look and feel and then also patent the code that generates that look and feel.
Maybe. Yeah. Well, software patents are a little iffy. So, but theoretically, yes, because patents do cover inventions, and inventions are functionality. Yeah.
You mentioned the look and feel of an app, right?
Mhm.
So the app gets reiterated, so the look and feel is changing. So
Right.
how does this copyright work in that scenario?
Good point. So the look and feel is changing. Apps are changing all the time. Thing that I failed to mention is that a expression of idea must be fixed in a tangible medium of expression. So stored in magnetic media or in a computer program, that's tangible media of expression, so it's fixed, it's copyright protected. But now you've gone to version 2.1 or 2.2, right? That 2 is going to be copyright protected. Okay, so each iteration, each instance of that software program is copyright protectable. Okay?
If you have an app, let's say, and then you use that app, and then you combine it with some other piece of software,
Mm-hmm.
and another piece of software, and you create a process that involves multiple pieces,
Mm-hmm.
is the process in whole patentable, even if the elements are maybe, like you license an app from somebody, from app A, process B, from different process C, individually they own those pieces, but you've combined them in a way that is unique. Can you patent that process even if you don't own the underlying intellectual property?
Theoretically, yes. You can patent a process. A process is patentable subject matter. And the fact that you don't own the pieces is not a big deal if you invented the process. Now, the fact that the process is being implemented by software makes it difficult to patent, but theoretically, it is patentable. Did I give you enough caveats?
It's distinctive enough.
Well, distinctive is not the right word, but yes, it's got to pass a question of novelty and non-obviousness. And non-obviousness is the hard one to get over.
Yeah.
But yes, theoretically it would be, yeah.
There are now generative images. Each time is generative.
An image, yeah.
Different images that
Copyrightable?
or somehow protect, possible to protect. That's basically an algorithm that makes an image every 10 different way.
Right,
Or image
in a software program.
Yeah, right.
Okay, and that image is stored? Is it stored anywhere for a moment?
Yeah, would be.
Yeah.
Yeah.
So it's copyright protected. So something that is in this fixed intangible medium seems to be causing some confusion. So if you think of like a performer in a play who has an elaborate makeup, let's say, okay, and a headpiece, and they're performing a play, that person, the makeup and the headpiece would not be copyright protected because it's not fixed intangible medium of expression. That performer is going to wash their face and take off the headpiece and it's going to go away. But the software program that generates images periodically, I would think those images are cached, they're stored, and those would be protected, but then the issue is why bother? Because if they go away, who's going to copy them?
What is protecting the image or the machine that stores
The image.
the algorithm that
The expression of the idea, the image.
So the algorithm is not cannot be copied.
The algorithm, going back to what these gentlemen were saying, the algorithm as applied to generating the image and creating that process could be patentable, because that's patentable subject matter.
If a new technology uses existing technologies but does something different for a different purpose, is that something that is patented? Can
Potentially.
be patented?
Potentially, yeah.
Theoretically or like in real terms?
Well, if it's unique and if it's novel and non-obvious, and then potentially, yeah, it could be patentable.
Even if it uses current technologies that could be patented?
Yes, we're going to get to that.
Okay.
Yes, potentially. Okay. No more questions. I get it. Should have taken this off. Okay, trademarks. Trademarks are a message to the marketplace about the product or service that they're associated with. So if you were to see this bottle, for example, with that logo on it, that name, you would know what to expect inside of it, right? Okay. So, and with each of these, you know what to expect when you see these. And that's the message that the source of that product has conveyed to you time and time again over the millions and millions of dollars of marketing efforts. And that's the effect of a trademark. And it could be anything. It could be a word, it could be a slogan, it could be a color, it could be a smell, it could be a sound, the MGM lion, but something that is distinct and is associated with a product or service is protectable by trademark. The shape of this bottle is potentially, it is protectable as a trademark because it is a message to you as the consumer of what is associated with that shape. Now, the bottle design could also be protected by a design patent, and it may even be protected as a copyright because it is a design. So, intellectual property, and I know I'm going quickly, but if you think about it, it's like this fabric that is woven to protect products and services and can interact with each other, and each has its own strengths and weaknesses. And that's where I really want to go with this. It's not so much important that you understand all the nuances here about what intellectual property is. Just keep in mind, inventions are protected by patents, expressions of ideas, copyrights, trademarks are messages to the market about a product or service that it's associated with, and trade secrets, confidential information, secrets. Think Coca-Cola formula with the WD-40 formula. Okay, so what, right? Why do we care about patents? Well, patents are they are powerful forms of intellectual property, and they protect a wide variety of inventions, as we described, processes. It could include software, manufacturing processes. You don't need to commercialize your invention. A patent can be infringed, can be violated by not even ever having a product make it into the marketplace. And that's really sort of the power and the danger presented by patents, because as an entrepreneur, you can protect your intellectual property. If somebody happens to step in your trap, so to speak, they could be they're a violator. But also, if you happen to go out into the marketplace with a product without knowing it, you might violate somebody's patent, somebody else's patent, somebody's patent that you've never even seen a product for. They can be, and that's the point about being enforced against innocent infringers. You don't have to have knowledge, there doesn't have to be copying involved. And there's strong legal remedies. So legal remedies are damages, how much money the violator will have to pay for the infringement. And if the infringement is found to be what's called willful, meaning that the competitor or the violator actually did this knowing about the patent, the damages can be increased up to 3 times the measure of damages, which is lost profits typically. And then a real powerful form of remedy is what's called equitable relief or injunctions. And that means you can shut down a company's operation, a company's sale of infringing products by court order. So these are really powerful remedies that patents provide to owners against violators. But what are some of the pitfalls? What are some of the shortcomings? It takes a long time to get a patent, and it's expensive. As I indicated there, the cost on the low end is $15,000, but as you sort of go through the process of obtaining a patent, it can go up to easily $25,000 per issued patent, and that can take several years to obtain. And just skipping down, and one patent is usually not enough. You usually need to have more than one patent to really have a defensible fortress of intellectual property. And the value of, and I'll say this probably a few times here, the value of a patent is in your ability to enforce it. Because you have a patent. Everybody's seen a patent with a ribbon on it? Seen what they look like? Yeah? Okay. Looks very impressive. Issue by the Patent and Trademark Office. There's a stamp on it. You show that to somebody who you think is violating your patent, especially if it's a large company, and they say, so what? Yeah, sue me. Yeah, I don't think I violate your patent, and I don't think you're going to do anything about it. So now you have to show that you're serious about enforcing your intellectual property rights, and what's that going to cost? You have to hire a lawyer like me or a law firm like ours to do that, and that's super expensive. I mean, easy $1 million, sort of all in, but that's just for starters. And there are lawyers out there that will take patent infringement cases on contingency for a percentage of the winnings, but not many. And they typically don't represent small companies that have just one patent. So that's not really a viable option. So that's kind of a downside. If you're going to be paying a lot of money to get your patent, and its value is in your ability to enforce it, and as a startup company, entrepreneur, you don't have that kind of money to enforce, right? One patent's not enough. And the other pitfall to keep in mind that people don't often know is patents don't give you the right to do anything, to use your invention, to practice your invention. They give you the right to exclude others from doing so. Kind of a weird concept, right? Seems counterintuitive. Let me give you an example. So let's say I hold the patent on a cell phone, okay? To use a cell phone to make telephone calls, which nobody uses it for anymore, right? And there's another patent out there for the cellular network, the system of using cell phones within a network to communicate and make calls, telephone calls. So I could, if I were to sell or make or use my patented invention within a cellular network, I would be infringing the cellular network patent. Make sense? So having a patent on my product doesn't give me the right to use it or make it or sell it. It just gives me the right to exclude others from doing that, from making, using, selling, offering for sale, or importing my product, my patent product. Does that make sense? Okay. Okay, so what do we do now? Patents are kind of, not, they're kind of pluses and minuses. Well, there are trade secrets. Trade secrets are kind of the flip side of patents. So if you think of a patent as a published document that describes the invention. You can go to the USPTO website and look up patented inventions or inventions that are pending patent protection, okay? And anything that has been filed within or after 18 months, so after 18 months after the filing date, is public information, and it's generally going to be on the USPTO.gov website. Now, trade secrets are secret information, confidential information. So if you have a patent application or patent that's published, it's no longer secret. Right. That's why it's the flip side. So as an entrepreneur, you have to make a choice. Am I going to patent my invention, or am I going to keep it a trade secret? Trade secrets are great because they're super, super cheap. Okay? They don't cost anything to protect. You don't have to register them. All you have to do is keep them confidential. They have immediate effect. You don't have to wait for the patent office or to come back and issue it. As long as it's secret, it's protected. It can last forever, as long as it's kept secret. Trade secrets are protectable. And they also provide benefits. We were talking earlier about how IP, intellectual property, is sort of this interwoven fabric of multiple forms of IP working together. Sometimes in doing a license deal, let's say, of a patent, it will also involve a license of trade secrets that aren't disclosed in the patent, obviously. Why is that? Because it's helpful to the person receiving the patent rights, whether it's a license or it could even be a sale, to know how to build the patented product. And sometimes that know-how is in the form of trade secrets. I'm going to give you a license to my patent, and I'm also going to give you the secret recipe on how to use it and how to build the product that is covered in the patent. So actually, trade secrets can enhance the value of other intellectual property in that way. It's oftentimes you'll see the term technology package. We're going to transfer our technology package to you in exchange for $1 million. What's in that technology package? It's specifications and documentation related to how the technology is going to be used. And strong legal remedies as well. I mean, there are lost profits that can be recovered from stealing, misappropriation of trade secrets, injunctions like I talked about before, a court order stopping the manufacture or the sale of the products that embody those trade secrets. And in some cases, criminal penalties. We've heard of corporate espionage, right? Piracy by stealing intellectual property. That can result in criminal sanctions. So that sounds pretty good. Why don't we just protect everything by trade secrets? That's cheap. You don't have to pay me. Well, there's a catch, as there always is. Catch is you have to keep it secret. And what good is a secret if you can't share it with somebody? So what do you do to share your trade secrets with somebody? You have to have agreements with confidentiality provisions. You have to have confidentiality legends on documents and materials that you share that embody your trade secrets. Security procedures within your organization. And there's an out for a violator, somebody who you might sue. And that out is reverse engineering and independent development. If somebody happens to figure out your trade secret by taking it apart, taking out part of your product or whatever, they can do that. And they're not stealing your trade secret. They're just clever. Unless you have a contract with them that says no reverse engineering. Okay, then they'd be in breach of that contract. Enforcement can be difficult. What does that mean? How can that be? Well, I was involved with a client recently where they said, our partner, our development partner, has stolen our trade secrets. They're using our trade secrets for scientific discoveries without our authorization. It's like, oh, okay. What are your trade secrets? Well, do you have a list? No, they're all in my head. Great. Now, the next 3 weeks, it's a matter of getting what's in their head onto paper and then going through them one by one to say, well, is this a trade secret or not? Does it meet the criteria? And the criteria, by the way, not just everything that's confidential, it's got to provide its owner economic value by virtue of being kept secret. So if it's just worthless information, that's not a trade secret, but it provides economic value to its owner by virtue of being kept secret. So the problem is that companies and entrepreneurs that have trade secrets, protectable trade secrets, know they do, but they don't know specifically what they are. They don't go to the trouble of actually memorializing them. And then there's the issue of, well, what do you do about wanting to share your trade secret, your confidential information with somebody who doesn't want to sign a non-disclosure agreement? Happens all the time. In fact, I was working on a deal recently where the other party is a major, I'm not going to name it, but it's a major chip manufacturer in San Diego. They wanted my client to sign a non-confidential agreement. Everything you tell us is not confidential and you will never sue us over using it. Okay? Why is that? Because they were concerned, rightly so, about taint. How do they know that they're not going to receive some information from my client that actually is information that they already have, and then we can come back later and say, hey, that product that you just put out on the market, that contains our trade secret information, now you're in violation of the NDA. They wanted to kind of see what we had first, verify that they don't have it, verify that they actually need it to see if they want to do a deal with us. And of course, on our side, it's like, well, how much do we tell them without them just deciding to do it without us? So it's tricky, right? Okay. So now it gets better. Okay, so, copyrights are powerful. They protect a wide variety of works, like I said earlier, sculpture and user interface and look and feel. And it's not just the word, the word copyright means, copying without authorization, without permission, is a violation of the copyright. But it actually goes beyond just mere copying. It covers a little bit beyond that. That means copyright infringement can cover things that are substantially similar to the copyrighted work. So it doesn't have to necessarily be identical. So that's good. There's good protection. And it lasts a long time. I mean, practically forever. You don't have to register to get protection. And it lasts, in some cases, 70 years after the death of the author or 95 years after publication, or even up to 120 years, depending on the circumstances in which the work was created.
What do you mean by publication?
I'm sorry, this is copyrights.
Oh, sorry.
So copyrights protect, thank you for bringing that to my attention. Copyrights cover the expression of ideas. And so, so these are, and fixed in a tangible medium of expression, and so it could be, if it's a musical performance, that's not copyrighted unless it's recorded, but the musical score would be. And there are strong legal remedies, incredibly strong legal remedies. In fact, this thing called statutory damages, where the plaintiff, the copyright holder, can recover up to $150,000 per infringing copy, was the basis. I don't know if you remember sort of the Napster cases, about 10, 15 years ago, where these poor college kids were getting nailed by the RIAA for millions of dollars because they were downloading songs from Napster And then the IRAA said, Recording Industry of America, said, you've got, 1,000 copies at, $150,000 per copy, pay up. So these remedies could be extremely strong. Now, I said here, registration is not required. You don't have to do anything, right? But you do have to register a copyright to enforce it. That's no big deal. You can file it at any time. So this all sounds pretty good in terms of powerful IP that can be used to by an entrepreneur. And it's not very expensive. Registration even is very inexpensive. This is my punchline. But it's not perfect. Copyright does have its limitations. It doesn't protect ideas, as I said earlier. And independent creation is a defense, so you actually have to prove that the infringer had access to your work to make a copy of it. So if somebody happens to come up with the same expression, the same artwork, for example, this is a Rothko in the background, by the way. That I didn't independently create. We'll edit that out of the video. But independent creation is a defense because it does require copying. Registration of software can be cumbersome. There was a gentleman here who asked about, or maybe it was a woman, I forgot. Oh, the woman back here who asked about multiple instances of software. Or if you're going to register multiple versions of software, that can get very complicated if you, because you have to keep track of it all. You're registering 1.0 and 1.1 and 1.2, and most entrepreneurs, they're busy just running their business. And they can't really be bothered keeping track of all the registration applications that they file for each version of the software that they have created. And so definitely, a company like Microsoft, they have teams of lawyers. It's going to be an awful job, but they have teams of lawyers doing nothing but just copyright registrations for all the versions of the software of all the various products that they have. And that's great. But as a startup entrepreneur, generally not going to be something that's going to be on your priority list. And then fair use is a defense. You've all heard of fair use? Raise your hands if you've heard of fair use. Okay, good. Now, raise your hand if you've heard this myth that if you only copy like 10% of the work, then that's fair use. Have you heard that? Okay, well, you didn't hear it from me. Because that's not right. Fair use is a defense. So when clients come to me and they say, hey, I am, I'm using this, I got it off the internet, but it's only a small part, and it's fair use, right? I said, well, first thing you have to remember is it's a defense. That means you're getting sued, right? Do you really want to do you want to get sued and then have to raise this as a defense? Probably not. Second is it's a balancing test. There are a lot of factors that go into whether fair use applies. And the courts have really struggled, particularly in technology, particularly in software, as to whether fair use applies. And the Supreme Court has come out with decisions on fair use. So what startup entrepreneur has sort of financial wherewithal to take a fair use case all the way to the Supreme Court? Not many. But this idea of fair use is interesting and important to know about. Transformative use is something that comes up in the tech area quite a bit. If you're using a copyrighted work, but you're transforming the manner in which it's used, transforming the use of it, that could be a fair use defense. And I'll give you an example. So years ago, there was a case against Google where Google was reproducing on its search results page thumbnail images of websites that would come up on search results. Okay, and some of these thumbnail images were actually photographs, and some of these photographs, and I'm not going to tell you what they were of, and some of these photographs were registered copyrights. Okay, and it's a copy, they're copyrighted, and it's protectable for copyright, so there's a violation, it's infringement. But the Supreme Court, I think, well, actually it was the Ninth Circuit, I think it was the Ninth Circuit, may have gone to the Supreme Court. Well, in any event, the ruling was, this was not the same use. The image on the website the purpose of it was for consumers to view these images, to view these photographs, but the use on the search results page was so that users can navigate to the website. They can find what they're looking for on the internet through using the search engine. And so this was a classic case of a transformative use that qualified for the fair use defense. But don't rely on it without really having somebody, here we go, sorry. Really look at whether your use is truly transformative. Okay. I'm sorry?
Rock fair use or transformative use or?
It's
It's
unclear. It's unclear.
If you use it, it's not fair use. If he uses it, it's unclear.
I'm teaching, yeah. My argument is I'm teaching a class for free. Yeah.
You're not charging us for this, you would charge us, but it would be a little bit different?
Yeah, it would be commercial use, and it probably would, good question, it would probably take it out of the fair use balancing of factors. Now, the counter argument would be, well, wait a minute, aren't you doing this for some commercial purpose? I mean, you're not doing this just to be, a teacher. You're actually developing business. And my response to that would be, no, I'm not.
All of us are going to go into our presentations and use images, right? And we are going to, based on those images, we are going to impress our investors, and based on that, we are going to get investors. Right? That's
I hear what you're saying. And so,
what are we doing? I mean, we're still going to use it, but probably are we in trouble or not in trouble?
well, you need to hire a lawyer first. It won't be me because I'm doing this for free. But no, it's actually a good question. So, and I'm not going to give anybody legal advice here, and so I didn't say this ever. But the answer is, okay, people use images off the internet all the time, right? For PowerPoint presentation, investor presentations, whatever. And it's a question of, is it a violation? Probably. Technically, it's an academic issue, yes. Is it going to be enforced?
No.
Probably not. So that's the risk calculus that an entrepreneur goes through. Am I violating the law? Am I doing something that is just pushing the envelope a little bit too far? And what are the risks and consequences of doing it? And it's always a cost-benefit analysis. I'm glad you brought that up because, this is a great segue to talking about IP, how to use IP in a startup and how to build a portfolio. I'm going to talk about trademarks really quickly. But it is a cost-benefit analysis. Everything that you will do as an entrepreneur building your business is going to be a cost-benefit analysis. So, power of trademarks, cover a wide range, wide variety of types of marks, as we talked about, and even sounds and smells, colors. This is, you recognize this blue? Yeah. You can get protection in the United States just by using a trademark in association with certain goods or services without registration. It's called common law rights. You can acquire common law rights. How am I doing on time? Do I have time for a quick story on common law rights? Okay. So, 1996, Amazon got the federal registration for Amazon to sell books on the internet. And that gave Amazon nationwide coverage for selling books under the mark Amazon. And lo and behold, there is a feminist bookstore in Minneapolis called the Amazon Bookstore that had been using the trademark since 1977. And under trademark law, under common law rights, the first user in commerce has priority. And so if you look at a map of the United States, Amazon had rights to the Amazon trademark across the entire United States, except for the geographic area where this bookstore operated in Minneapolis under that mark. And so Amazon, they couldn't just like take Minneapolis out of their, their network of selling to users. So they had to take a license, and good for that trademark, common law trademark owner, bookstore owners, because they were able to get a nice license. I think they had to actually go to court against Amazon, but they did secure a nice reward for having those common law rights. So you don't have to have registration for protection. They can last, trademark rights can last indefinitely, forever, so long as you continue to use the trademark in commerce or with the goods or services that are associated with your trademark. So some people will say, I want to lock up this name. I've got this great name, I want to lock it up. Okay, great. We could file a trademark registration, but at some point, and you're not going to lock it up, you're going to acquire trademark rights for it, but at some point, you're going to actually need to make good on the intention to use that trademark with your product or service. Question?
So actually, two questions. Is the filing of the trademark, does that give greater protection than the common law rights? If you've done the filing versus you haven't? And the second one is, if Amazon files, because I know it's done by class.
Right.
So if the bookstore in Minneapolis sells physical books versus Amazon is an e-commerce bookseller, wouldn't they potentially be in different classes, so there wouldn't be a violation?
Potentially, but you're looking at it like a normal human being. And the trademark office.
A long time.
The trademark office would look at it. So, no, but really, first of all, federal registration gives you nationwide coverage. So there's a presumption that you're using it nationwide. Common law rights only give you rights in the geographic area where you are marketing and using the mark in association with your goods and
Even if
services.
you're online?
Well, that's the problem. If you're online, you're using it everywhere. Right. So that's why Amazon couldn't just say, well, we're not going to use it in Minneapolis. If it had been the other way around, and Amazon was a common law rights user, then arguably they would have been able to say that they had rights everywhere in the United States. But there are other advantages to federal registration. Just really quickly, federal registration goes into the database at uspto.gov, and so you can do searches as an entrepreneur to see if anybody has your trademark for the goods and services that you're using, to give you kind of a preview on what your risk is of using a proposed trademark. It also gives a presumption of validity, have the Circle R registered marks. There are benefits. And then you can recover attorney's fees, potentially, if you sue for trademark infringement. The other question is, and I just had it reminded me, second question.
The classes.
Right. So the test of trademark infringement and the test of whether you're entitled to a registration for a trademark is likelihood of confusion. Is a consumer of your goods under your trademark likely to be confused into thinking that they come from the same source as the other trademark goods? So if you're comparing two goods, so let's take the different classes. Amazon selling books online versus in a bookstore. A consumer that sees Amazon.com who maybe is from Minneapolis might say, oh, they went online. There's a confusion of source. So that's the litmus test. It used to be that you can make arguments like that. Perfumes are different from soaps or lotions. Therefore, we should be entitled to the same name trademark. We could coexist in the marketplace without likelihood of confusion, right? The trademark office that issues trademark registrations recently, I would say probably within the past year or so, is now gotten very strict in rejecting trademark applications of the same trademark, even for different classes of goods. And so you may say, you may get very angry with your trademark lawyer saying, well, why didn't you get this trademark? The classes are different, the goods are different, and it's because, well, and by the way, not all examiners at the trademark office are the same, so you may get one that's a little bit more lenient than others, but there's some that are really strict, and they will reject based on the same word. They'll want, but if you differentiate it somehow with a logo, word and logo, or a combination of different words, then that might be enough. Does that help? Yeah.
So is it that evidence of use of the trademark in commerce that you actually have been paid for the product or service associated with
Not
that?
necessarily. No, not necessarily.
Okay, so what's the minimum bar?
It has to be a trademark use, it has to be legitimate, maybe selling it to a, or it could be a free sample, right? So it could be a sample, shipping, interstate commerce, that's the bar. Advertising is not really use per se, but promotional activities, perhaps presenting at conventions and trade shows.
Okay.
Does the trademark apply globally, or would that be different?
That would be different. So this is only U.S. Now, the U.S. has a treaty where the Berne Convention. Rita, what is it?
I forgot the name.
Yeah, I
I'm
forgot.
sorry.
Treaty of Paris, Berne Convention. I'll think of it in a second. Anyway, there is a treaty where you can have priority with respect to your filing date that will be transferred to foreign countries. But at the end of the day, you do have to prosecute your application in individual countries. Yeah. Back in the back.
Yeah, so like, if like the movie over 25 years, can you know, I heard this like you able to use like, like for research or whatever, or you can use for your own purpose. Is it true?
So that's copyright. And so the question is
After 25 years.
after 20. No. So first of all, copyrights last a lot longer than 25 years. And so what you're suggesting is if there is a copyrighted work that has entered the public domain, can you use it without violating the copyright holder's rights? And the answer is yes, if it's entered the public domain, but it takes a long time for that to do so. There was a period of time where the copyright laws were different than they are today, where you had to renew them periodically. And some people failed to renew, I think it was Rear Window, that failed to the Rear Window movie. The studio failed to renew the copyright, and it fell into the public domain. But that doesn't really happen anymore.
So like if I do the documentary, I need to have some sort of, like, just like whatever, NBC, CBS, when they have some part of for documentary. I heard this like after 25 years, like the public, this like can use. So
A lawyer told you that?
not another filmmaker told me. So I just,
Another filmmaker told you, okay.
so I just want to make
Hire him
sure.
as your lawyer.
Yes, so I want to make sure, So like that one is a copyright, not a, so like the trademark is nothing to do with movie?
The trademarks protect words, logos, slogans, not the titles of movies, but it could protect a series, a title for a series. So Star Wars, for example, is probably protectable as a trademark for a series of films. But it's the word, or the design, or the logo. It's not the film itself. It's not the expression of the idea that's in the film. The gentleman in front of you had a question.
The question about the utility of patents for small firms. We have a situation where we got a patent that's probably about half a dozen years old. It's being infringed by at least a dozen major companies. I'm talking about firms with $100 million in sales and more, where it's fundamental to their operation. The damages would probably be, they could be $100 million. Our total sales are less than $1 million from what you're saying, there's nobody going to take this as a great utility on a contingency basis.
I didn't say
Many of
nobody.
these,
I said it's hard.
well,
It's hard.
well,
Yeah, go ahead, I'm sorry.
it strikes me, any one of these people will be able to, any one of the infringers, will be able to keep it in court for a dozen years, and the question whether they're still alive, or children will be graduated from Harvard.
So I'd be happy to talk with you offline after the presentation about that.
Contingencies?
Just the pros and cons of kinds of things that contingency fee lawyers look for. But I want to kind of keep the questions
What
in
about
mind
the
of general
general
application.
situation? Because this is not unique. Small companies
Yeah.
are infringed upon by big companies, and they don't have big lawyers. The big companies do. What use are the patents?
We'll get to that, I promise. That's the part of the talk that I'm going to get to. That's the interesting part at the very end. The last slide. The very last slide. Okay, where were we? The other thing I want to mention is that trademarks can enhance the value of other intellectual property. So if you think about Coca-Cola, what did I say about Coca-Cola earlier? Who remembers what form of intellectual property it is, the formula?
Trade secret.
Thank you. Okay, now I feel heard. But if you think about it, the most valuable, and this is true, I forgot what the numbers are, but the most valuable aspect of the Coca-Cola company's intellectual property is its trademark. Right. Because it really built up a market, built up brand recognition, created brand equity in that trademark. And so trademarks can enhance the value and surpass the value of other intellectual property. Maybe I'm just an IP geek. I think that's really fascinating. So here's the problem, though, with trademarks, right? They don't protect descriptive or generic words or identifiers. Everyone thinks, oh, I want to lock this up. I want to, get a trademark for, I don't know, car, to sell cars. It's like, no, you can't do that. Descriptive and generic trademarks are not protectable. Well, that's no fair. That makes it hard. Yeah, that's the point. It's intellectual property. So the way to think about when it's protectable, what makes a strong trademark, okay? Here's the $50,000 moment, is sort of the mental work one has to do initially to connect the trademark to the product or service. So think about it. Before you were addicts of Starbucks coffee, you saw Starbucks, you saw the name, you'd say, what the heck is that, right? It took at some point in time, a fair amount of mental work to associate Starbucks with coffee. Some time ago, same thing with Apple. You didn't buy when you saw Apple or that logo, oh yeah, computers, that's right, or iPhones. No, you had to do some mental work. And so as entrepreneurs, if you're thinking about coming up with a trademark, most entrepreneurs, I hate to say this, but most of them come up with descriptive trademarks that are not protectable. And so think about, something that is abstract, something that is fanciful, something that is maybe suggestive of the customer experience of using your product or service, as opposed to telling the consumer exactly what it is. And people will say, well, gee, we're going to have to spend lots of money to kind of get that point across to consumers, to let them know what, Fleck is, for example. Well, that's the point. That's why that makes for a very strong trademark. You can lose rights through not using the trademark, so you have to keep using it. You have to declare, send an affidavit to the trademark office if you have a registered trademark to continually to prove to them, the trademark office, that you are using the trademark in commerce. And then there's this issue with foreign registration. It's easy, actually, to register. It's more difficult here in this country to obtain trademark registration because you have to show the trademark office that you're actually using it in commerce. And a lot of times entrepreneurs are planning to use it, but it takes them a while to develop their product and market application. But in foreign countries, many foreign countries, you can register a trademark just by filing a registration application. You don't have to show use. And so many times what will happen is a third party in a foreign country will register a trademark. This happened all the time, but now it doesn't happen so much because companies, American companies got onto this. They would file, Nike in, I don't know, some country, let's say in Asia, and then Nike would go into that market and they'd find, oh, it's already registered by somebody else, and then they have to pay extortion money to that registrant. And then registration can be canceled by misuse. So what does that mean? You know what I was talking about, that message to the market? That message has to be consistent. And because what you're doing is you're telling consumers what to expect inside that bottle or that box that has your trademark on it. So if you, and I had a conversation with a client earlier this evening about this, if you don't use your trademark in a consistent manner, sometimes it's with other words, sometimes it's by itself, sometimes it's uppercase, sometimes it's lowercase, that could make your trademark susceptible to being invalidated. Same thing with quality. Consumers will expect a certain level of quality from your trademark that they are used to having, experiencing. And so if the quality of the product is variable, then that means that you're not doing a good job of communicating that message about your product to the market in association with your trademark. And again, that could be a basis for invalidating your trademark registration. When does this happen? When does these challenges come up? At the worst possible time, of course, right? When you go to enforce your trademark against an infringer, and these defenses, invalidity, abandonment, are brought up. And so that's why you want to avoid that from happening. So let's talk about building an IP portfolio on a startup budget. Okay? So what this is supposed to show is sort of the stages that a growth company goes through. So there's first development, you're developing your MVP, you get some validation, you get customer discovery, you're scaling up, growing, and then mature. Your IP strategy also has a growth pattern or path of what I call preserve, plan, accelerate, and dominate. So what does that mean? So first of all, have you seen this curve before? The valley of death? As a startup entrepreneur, you need to survive the valley of death. And that is, you start out, you've got this great idea, you're building your product, and you don't have any money. And you need to get past this in order to get out into the market, in order to attract the real money that's going to help you scale up. And so this curve, and every company is different, has to kind of mirror this progression with respect to your IP strategy. Because if, trust me, spending all your money on patent, are there any patent lawyers here? Okay. Spending all your money on patents is not going to get you past that. Unless you're a company that is in the business of licensing intellectual property. That's one exception. Yeah.
Like my family have a lesson that
I'm sorry, what?
my family, my family member have like 5 patents, like in the chemical about iPhone here. And in the beginning, because we found the patent, and then it's like that belonged to us, but then it's like another company because they so damn rich, so it's like they say it's intelligent. When you work for someone, that one you research at home, but then it's the company they say it's an intellectual property, it's belong to them, even though you work outside at home. So I keep wonder, you know, like if you work for someone else and you have the idea and you work at home, is it right for them to say is that, you know, they own you 24 hours, 365 days?
So that's a little off topic. I would be glad to talk with you after the presentation, but I want to kind of keep the questions to sort of ones that are of general application. But I'm happy to talk with you afterwards. And I should have mentioned earlier, I should have said this at the outset, everybody who asks a question gets to be the butt of my jokes. So, right? Okay, so what I was saying here is mapping that curve, funding curve, and capital requirements curve onto the patent strategy. So how does that happen? Let's talk about the development phase. So like I said, you're creating your MVP, you're doing customer discovery, you're developing your business model. And one thing that, but you have very little money. And so one thing that I have learned as a startup lawyer is innovators continue to innovate. So your first invention is not going to be your last invention or innovation. And so there is a tendency to, at this stage, to say, I want to lock up my IP, okay, I want to file some patents. And I just don't think for most companies that's the right approach. And the reason is you're iterating. You are testing your business hypothesis, you're identifying what your market is, you're developing the product market fit, and if that hasn't yet gelled, then why spend a lot of money on protecting something that may not be worthwhile down the road? I'm not giving you legal advice, I'm just giving you some food for thought. It's a cost-benefit analysis. So if you have unlimited funds to spend on patent lawyers, that's great. But what you're doing is you're sort of testing what's working and what doesn't work. And so you want to be, what's the goal here? IP aware. What does that mean? You want to be aware of intellectual property as you're creating it. Okay? So, generally, it's a more forward-thinking process as opposed to one of, I created this, I'm going to patent it or I'm going to protect it, check the box, and forget about it. That's not the approach. What you want to do is you want to be, and that's why I did the slides earlier about what is IP. So now, hopefully, there's an awareness that is being developed as to what various forms of IP you are creating in your business. Are these trademarks, trade secrets, patentable inventions, potentially copyrights, okay? So what do you say to the investor who says, so do you have any IP? Is anybody raising money, by the way? Yeah, okay. Anybody funding, any investors? They never raise their hands. Good. So that question often comes up. I often have clients say to me, what do I say to these investors when they say, do you have any IP? Do you have any defensible IP? Where's your IP? And my answer is generally, look, we're a startup company. We're in development mode. We are aware of the IP that we have created and that we continue to create. We are preserving, and on my earlier slide I had preserve, we are preserving the intellectual property that we have and that we have created by having agreements with our employees and independent contractors, by having non-disclosure agreements with anybody that we share our confidential information with, by having policies and procedures within our organization to not disclose inadvertently information that is critical to our business that is confidential. We are really being mindful about how we preserve our existing intellectual property. We have consulted, hopefully, patent IP counsel who is guiding us through this process. And we have plans to implement an IP protection plan after we close our round. And I think that's a reasonable So, this is about sort of preserving what you have and knowing what you have in the first place without losing it. Okay? So the next stage is validation. You're going to, this is where you've developed your MVP, your prototype, you're validating market adoption, perhaps your business model, pricing, maybe getting customer feedback. And what are you doing? Now you're starting to, and maybe you've closed a round. So now you're starting to think more proactively about taking steps to protect IP. Now, in my earlier slide where I said preserve, plan, accelerate, and dominate, I didn't use the word protect. But here, when you're implementing processes, you're thinking about proactively protecting. And what does that mean? Well, let's talk about patents. So maybe you have a process for what's the first step in this process for identifying potentially patentable inventions is to write it down. What is the invention? Write it down in a invention disclosure form or report. And what an invention disclosure form is, can be as simple as a blank screen on your computer and just start typing. But if you leave your business card or email at our reception desk, I'll send you a form of invention disclosure for free. So I'm still within fair use, which gives you some prompts. But here's the key to filling out an invention disclosure form. Number one, describe, and this is, I'm not going to kid you, this is painful stuff. I mean, this is really sitting down and thinking hard and really boiling it down. Describe your invention, it's like writing a recipe, as if you were teaching it to a 5th grader. Okay? Really peel the onion and get to its base level and then build up. And then once you've done that, and I've had engineers, my clients, engineers send me their completed invention disclosure forms. Okay, I'm done here, Kevin. And it's like 2 paragraphs. Like, no. Go back and really spend some time with this. And then when you're done with that, then put yourself in the shoes of a competitor and think about, okay, if I'm going to do this and work around this invention, how would I do it? How else would I implement this invention? And this piece of work serves 2 purposes. One, it gives you inventory in your IP stock. What you're doing is you're creating an inventory of inventions. You're keeping track of them. And this process that I'm talking about is periodically you're going to evaluate that inventory, you and your co-founders, members of your team, and decide what you're going to invest in for maybe a patent application, or decide what the best form of intellectual property protection is for that innovation. Okay? The other benefit or reason you're doing this is patent lawyers are obscenely expensive, even the cheap ones. Okay? They are. Because, sometimes they do things on a fixed fee, but it's still expensive. And it gets more expensive, or the expense is a function of how much work, how much time they have to put into it. So if you do a lot of the homework for them, then theoretically it should be less expensive than it would be otherwise. Okay? So you want to give the patent lawyer who's going to write up the application, everything that they need, and they can come back to you with questions and so forth, but everything they need to really kind of get started as opposed to pulling it out of them. Okay? Same thing with trademarks. You're going to be testing the market. You're starting to think now, have a process for identifying some trademarks. How are those trademarks going to be to mesh with your your target market, the customers that you are identifying, and in what markets are you going into? Are you going into foreign markets? How would your trademark translate in foreign markets? To develop a branding strategy. Who are your marketing partners going to be? Who are your distributors going to be? Or are you just going to sell over the internet? So all these things come into play in this process that I'm talking about of starting to think proactively about intellectual property. Does that make sense? Okay. So, you know, this is a, you know, if you have a great idea, I found this to be true, actually, and this says it all. If you have a great idea, really, you can't read it? We better patent this so the Homo sapiens can't steal it from us like they did with fire. If you have a great idea, chances are somebody has already thought of it or is currently working on something similar. Independently. It's just, you know, in the air. I've seen this happen time and time again in different parts of the country. I was involved in a patent case back in the days when I was a litigator. It's a whole different life. And my client was an inventor, and he invented a product, and we thought the defendant stole the invention because it was identical to ours until we got the inventor's notebook. This is aging me, it shows you. This is an inventor's notebook, it wasn't on a computer. And the date of his first sketch of the product that they came out with that infringed our patent, we got the patent, was 4 days after our date of conception. 4 days in a different part of the country. So, you know, if you have an idea, act on it, and the first thing to do is write it down and maybe start thinking about, maybe see if it's something that you should pursue patent protection for. The law changed in 2013 where two inventors of the same invention would be entitled to the patent if they were both to file a patent application. And it turns out that it used to be the first inventor to invent the invention, so there used to be this sort of crazy process in the patent office. It still, I think, exists today for things that are still pending from back then. But where you would have these sort of secret envelopes, each party would submit their secret envelope of when they invented, and then they get opened at the same time, and the one with the first date won the patent. It's called interferences. Now, the law changed in 2013 where it's the first to file. The first inventor to file a patent application on the invention vis-a-vis another inventor of the same invention, the first one to file is entitled to the patent.
Quick question.
Yeah.
If in a company, usually your employees, the company owns or intellectual property you create while you're an employee.
Yeah. Yep.
In a patent filing, usually there are a list of inventors, names of people who are inventors.
Right.
What's the value of putting the names of the inventors if the company owns the patent?
Because the company owns the patent. So the question is, you know, why have the names of the inventors on the patent application or the patent issued patent if the company owns the patent? Well, it's actually the inventors, and then we're going to get to this. The inventors own the patent that gets issued, but they assign and transfer their ownership rights to their employer. So you will see assignee employer X, Nike Corp. Nike. Okay, so now we're scaling up. We've got some venture capital money. We've proven that we are. How am I doing time-wise? Okay.
Let me just add one more thing
Yeah.
to what you said. That it's also important that only the people who actually worked on inventing the thing are named as inventors, because that's a way that people can break the patent.
Right.
So don't let your boss, say, I funded you on this, so I get to have my name on the patent. That's not good.
But it's still assigned to the company anyway.
Yeah.
But you don't want to make it easy for somebody to break the patent.
So now you've got some money, you are scaling up, and importantly, now you have additional product offerings. So you're differentiating the product line, you may be entering new markets, you're entering foreign territories. And so now you have your processes in place for evaluating intellectual property on an ongoing basis and deciding the best way to protect it, whether it's through patents or trade secrets or otherwise. And you're building a portfolio. Why? Because patent wars are fought with portfolios. They're not in IP wars. So it's, that fortress that I showed you earlier, that's what you're creating. You're creating a fortress of intellectual property. And the important thing about building the portfolio is that portfolio should, doesn't always happen this way, but should map or correspond to your business strategy, your business plan. So many times where there's dysfunction at this level is companies the IP lawyers are operating in their little bubble, and then the business people are operating, running the business, and the two don't talk to each other. And so what ends up happening is you will have a bunch of IP, and you'll have a business, and there isn't sort of a lot of correspondence between the two. Why is that important? Well, number one, your point, earlier, is patents are expensive to maintain. After they're issued, after you pay the patent lawyer all that money to get the patent for you, and remember, it's not just one patent, but it's portfolios. We're developing multiple patents. You have to pay the patent office a maintenance fee, thousands of dollars periodically at 4, 7, 11 years after issuance. And if you go international, you're paying maintenance fees to those foreign patent offices. This could add up to easily, I think, on a worldwide basis in most industrial markets, it could be $75,000, $100,000 a year for a patent. And so you multiply that by the portfolio. And so that's why it's important, even at this level, even where you are scaling up and you have funding and you have products and you have revenue coming in, it's important to periodically cull the herd to say, well, are these patents, are these trademarks still in use, still relevant to our business as we're moving forward? Maybe your business has changed. Maybe your product direction has changed. You want to periodically take a look at that so that you aren't spending money needlessly on these maintenance fees.
Yeah, when you say it's like when we have the patent and we already filed and we pay amount and you say it's for maintain,
Yeah.
year after year, we have to pay another fee. Can we deduct on tax?
I'm not a tax lawyer, so can't help you there. No, really, I don't know. My guess would be probably not, but I don't know. Maybe it's a business expense. Yeah. Okay, so last slide on this progression. See, when I do this the next time, I'm going to have this more. You guys are the guinea pigs. All right. So the value of a patent, the value of intellectual property ultimately is your ability to enforce it, as I mentioned earlier. So here's the mature phase. This is the dominate. This is where the company is established, is in multiple markets, multiple territories. And so here, in order to dominate, you use IP for BI, business intelligence. And so this is where it really kind of gets interesting, because now you can do things like, and it's expensive, but you're a mature company, and you have people in staff. You have a VP of innovation with a team that sort of runs this like clockwork, and you do patent mapping. What that means is you're identifying areas where patents have either been filed or are issued in different areas of technology of interest, and that enables you to identify white space. And so the white space is the area that isn't very active, that maybe has been overlooked by your competitors or other companies. And so that business intelligence can do a number of things. Number one, it can help you direct where you want to develop product or develop technology. And so it can inform your technology roadmap and R&D activities. It can also give you information about competitors not just who they are, but how fast they're filing, the velocity of their patent filings. And this can tell you sort of the rate of their innovation and gives a lot of information about how much of a competitive threat they are. Also, it can identify potential infringers of your patent. If somebody is close to where you are, you may want to take a look at their products and see if they are potentially infringing your patent. So this is, and the same thing when it goes to trade, when it comes to trademarks, we do some really interesting things in terms of watch services, periodically monitoring filings of other trademark applications that are close to yours, doing searches periodically to find out who's coming close or what is available in the future as you start to map out your product line in the future. So for example, in contrast, a lot of companies will come to me and say, we want to develop, we're coming out with a product in 2 weeks and we want to register this trademark. Okay, fine. The better approach is, we have this product or these products on our product roadmap, this family of products, and we want to develop a cohesive trademark strategy that pulls everything together, that really gives us, it could be, we're going to come out with, and I'm not a marketing guy, but products we want to call one rose and one violet and one lotus. And so now you're starting to think in a cohesive and informed way, mapping your product offerings to your trademark and branding strategy. So that's where you can start using intellectual property for business intelligence to understand your competitors, understand and better suit your market that you're going after. Okay, so I'll pause there because I have about 4 slides or 5 slides on common mistakes that entrepreneurs make with respect to IP. This is the part where I deliver on the promise that it gets interesting. Okay, you're still awake, good. Any questions, comments? Yeah.
Yeah, well, I don't know if this is the right time, but basically you said earlier that process executed by software is very difficult to patent. And I'm involved in developing software for mobile applications. And my question really is, you argued against not doing anything, which is being aware before you're an MVP. Wait a minute, you put out an MVP, even for testing purposes. I'm going to roll out to 1,000, selected testers. My product is out there, and one of those testers could be someone who's thinking along the same lines.
That's right. Good.
So what's the best strategy in that case?
Good, okay.
And as a follow-up, just how hard is it? How do I know if what I have is, because I know that Amazon got something called a one-click patent, which I read through and I couldn't believe that patent.
Yeah. I'm not going to comment on that because it's a particular case and it's like, we'll be here for hours. You run your sleeping bag. But I will talk about, you raise a good point, that is, well, if we're going to, one of the things that can trip up a entrepreneur, an inventor, is by disclosing your invention publicly at a trade show, by beta testers, putting out a white paper, and then lo and behold, 12 months later, you're ineligible for filing a patent application or obtaining patent protection because there's a 1-year grace period for that kind of activity in the US, but even more importantly, there's no grace period in most other countries of the world. So if I had a client years ago that was making their product available to some beta testers and they wanted to go into Japan, so they need to get a patent application on file very quickly in order to prevent them from being barred from pursuing patent protection in Japan by virtue of having done this beta test. So, is that contradictory? Somewhat, yes. Here's the answer, it's not legal advice. One is, yes, software is difficult to patent. Courts have struggled with it as subject matter, but I think the real reason is, for most entrepreneurs, is there are 3 requirements of patentability. I've said this before: novelty, utility, and non-obviousness. Non-obvious means that the invention was not obvious to a person of ordinary skill in the art, not an expert, but just somebody of ordinary skill in that area of technology at the time of invention. A lot of software processes, a lot of processes that are implemented by software are arguably obvious. And so that's where they get tripped up, is that the patent office will come back and say, well, you're implementing a software mechanism for automatically telling you what time it is to feed your pet. And, there are timers out there, so even in the physical world, so now just because it's implemented by software doesn't necessarily make it an invention. So it really, truly does have to, I think, be invented. So the advice that I give is, and most entrepreneurs think about their inventions and think about patents as the big idea. This is what I came up with, this reminder system for feeding my dog, but probably that's either already been done or it's not, or it's going to be obvious. So here's the thing to think about in that regard, and that is, have you solved a really difficult problem? Have you developed something that if your competitor were to do it, it would have to go through the same process, development process that you did? This inventive, I call that a choke point, a development choke point. So it's not very sexy, but it's not the big idea, but it is something that you can close off a competitor from getting to implementing your functionality, let's say in software. So my advice to clients is, don't think about it in terms of the big idea. Think about it in terms of solving hard technical problems and things that a competitor would have to do in order to implement the same functionality that you have. Now, the answer to your question is, what do I do? Because I think I've invented something, and patents aren't a great option for me, but I don't want to be precluded. Kevin, you said earlier, preserve and don't lose intellectual property rights that you may have. The answer there is, well, maybe you spend a few $1,000s and file what's called a provisional patent application. And a provisional patent application is a patent application light. It doesn't have it's not as robust as a regular patent application, and patent lawyers won't charge usually $15,000, maybe it's $3 to $5. And so that's sort of a way of, like I said earlier, you're not sure that your product is going to be the one that makes it into the marketplace. You're just testing it, but you don't want to lose your rights. So maybe the thing to do would be to spend a few $1,000s, file a provisional application. You have 12 months to decide whether or not to make it non-provisional and have it be examined by the patent office. In the meantime, you're not losing your ability to obtain patent rights down the road by conducting that beta test. Does it make sense?
Yeah.
Yeah.
But what's the best way to judge if you even need to think about it patenting? Because it's software, and you said process is difficult.
Again,
how do you make that assessment? I speak to someone like you?
Yeah. Possibly, but I think I would even recommend that you speak to a patent lawyer who is really in the trenches writing up patent applications. And if you want, I can recommend a couple who I work with. But and I should have said this earlier, I'll say it now. Sort of the difference between me and sort of the typical patent lawyer, though, is if you ask a patent lawyer, can I patent my invention? The answer is inevitably going to be,
sure. Maybe.
No, yes.
Oh,
sure. Yeah, they're going to say yes. You unless it's like a chair, Yes. And why do patent lawyers say that? Because they're just motivated by money? No, because the good ones are really good at what they do, and they look at it like a challenge. They can get this approved. And now, it may not be something that, what did I say earlier? The value of a patent is your ability to enforce it. It may not be the broadest patent in the world. It may not be one that's going to hold up to a challenge down the road. And so their goal is, they're just good at getting patent protection. because I come in from a different perspective, is how is it going to help you achieve your goals as a business person, as an entrepreneur? Is it defensive? Is it offensive? Is it strategic? Is it just to preserve your rights? Let's figure out what you're trying to accomplish first, and then that will determine whether it makes sense to spend that money, cost benefit.
Well, on the defensive side, another concern is patent trolls. So if you don't bother with getting a patent, and someone has something like it, they can then block you.
That's right. That's a whole.
Well, the provisional is just a placeholder.
Yeah.
Provisional is a placeholder, it puts you in line, so if
That's
somebody
right.
else comes up with something during the meantime, you're first.
That's right.
Is
That's
that
right.
correct?
That's right, yeah, first to file. That's right. So it gives you that first to file benefit. Okay, shall we do this common mistakes?
Yep.
And then we'll have a quiz.
There's only 4?
Would you like more?
Can you suggest one?
I think there are a ton. I did this presentation on mistakes earlier at USC, and I think I had 12. But I didn't want to overload you. I know it's been a long night, and I appreciate you sticking with me here. Okay, so failing to secure ownership. That's a big one. It comes up all the time. Independent contractors who create works of authorship that are protectable by copyright. We learned about what copyright protects. Without an agreement saying to the contrary, own what they create. So if you hire somebody to design a logo for you, it's a work of graphical art, it's a work of art, and as an independent contractor, they own that unless, even if you pay them for it, they own it unless you have a contract that says it's a work for hire, or you are signing all right, title, and interest in the artwork to me, to my company. Same thing with employees. If you don't get your employees to sign what are called employee proprietary information and inventions agreements, you had the question about employee inventors. Inventors own their inventions and the patents that result from them. There have been situations, many of them, where there wasn't an agreement in place where the employee transferred ownership of the invention and ultimate patent to the employer. What did the employer end up with? What's called a shop right. A shop right is a non-exclusive license to use the patent that ultimately resulted from the invention, but didn't get ownership of the invention or the patent. So getting contracts, employee proprietary information inventions agreements with your employees. And then also confidentiality agreements and the contractor and employees employee agreements I just talked about have confidentiality provisions. Those are important. Why? Because unless you're in an entrepreneur for social good, which is it's actually valid, or you're a nonprofit. If you're looking for an exit, if you're looking to get investors and you're looking to scale up and exit at some point, each step of the way, when you have investors or a potential buyer looking at your company and giving you an agreement to sign, it's going to contain representations and warranties. And those representations and warranties are going to say, you haven't given your trade secrets, your source code to anybody without a confidentiality agreement. And if you haven't abided by it, if you've, there was that person 20 years ago, you have to disclose it on a disclosure schedule, and that can be the basis of knocking down the purchase price. So you want to really secure your ownership and confidentiality, the confidentiality obligations of those who you share your trade secrets and confidential information with. So filing patent applications that do not target strategic inventions or valuable inventions. So this really goes to the point of trying to capture the big idea I was talking about earlier, as opposed to small but really critical to implementing certain functionality or the invention that may be more important, more of a block, more of a barrier to competitors. Using open source code software without knowing or without being aware of the restrictions. Is everybody familiar with open source software? Well, of course, I would expect you probably use it. So, open source software is software that is contributed by a community of developers, and it can range in a number of different things, but there are tools and utilities that developers rely upon in order not to reinvent the wheel in each instance as they are developing an application or a program. And it's free in the way that it's like free beer, but it's not free by...
It's hard to avoid.
Right. But it's not free in terms of being unrestricted. And so they are subject to licenses, the permission to use, and the permission to use the open source license has oftentimes restrictions or requirements that in some cases you have to publish the source code that you create, with this open source software. Or that you can't charge a fee or a royalty for the product that you develop with the open source software. And there have been lawsuits over violating these open source software license agreements. And so the takeaway here is, again, if you're an entrepreneur scaling up a company, looking for an exit someday, the buyer is going to say in the agreement, you have not included any open source software in your products other than those that you have scheduled in an exhibit to the agreement. And sometimes these exhibits go on for pages because developers of software companies use a lot of open source. So if you're going to use open source, know what the restrictions are and keep track of it. Because you will, just like trade secrets, you will need to know what you have in your products at some point in the future. This is the last one, and then we'll do questions, okay? So adopting a weak trademark, we talked about generic and descriptive trademarks. Here's a perfect example. Now what's interesting is that American Airlines, now they have a logo. They've changed their logo recently, and so that's their way of trying to create some distinctiveness. It's, I guess, of the eagle, stylized eagle. But, again, it's sort of choose trademarks that are going to build value in your company, build intellectual property within your business, unless you have a purpose for not doing so. But I guess my whole point here, and this is really the end, is, and I'll take questions, is thinkers, just be mindful of what you're doing in creating intellectual property. Be mindful of what you're creating, who you're sharing it with, what your options are for protection, and what you plan to do with what you're creating in the future. So with that, go build something.